main parties in this case are the Kingdom of Spain, which is the respondent, and the Anti-Infrastructure Services, Luxembourg, and Anti-Energia Termosolar, which are the claimants. These are the main parties involved in this case. The relationship between both of the parties is that the companies of Luxembourg are the investments that are located in Spain. Their main objectives is to gather and produce energy by energetic plants that are located in Spain.
The case started in 2008, when in Granada, Spain, the Andasol energy plants were created. The power plants are concentrated solar power, CSP, which means they exploit sunlight with minimal environmental impact. It is a form of solar thermal technology. However, these plants may also use fossil fuels in order to boost their power generation capacity. By using natural gas, CSP plants increase their solar to electricity conversion efficiency and durability of their production, which was the case of the Andasol plants. Spain at the time handled a double regime for the generation of electricity, one for renewable resources and one for more contaminating resources. This regime made companies that use renewable energy pay less taxes in order to promote green energy, as was established by the Institute for the Diversification and Energy Saving. The Andasol plants at the time handled the regime for more contaminating resources for the use of natural gas. However, in 2010, there was a lack of energy at Spain due to a financial crisis. For that, they created a new regulatory framework on Law 1614/2010, when the power plants that produce energy with a bit of gas could be added to the framework of green energy as a way to help them overcome the crisis. Many plants were added to the new regime, but the Andasol plants were not. In 2011, ANTIN Infrastructure Services Luxembourg and ANTIN Energia TERMOSOLAR companies from Luxembourg started investing on the Andasol plants. As these ones were not added to the new regime, they started the internal judicial process to settle down the issues with Spain, but they lose each process. Having banished all the internal judicial process in Spain, the Luxembourg companies decided to demand in Spain, under the breach of Article 10 of the Energy Charter Treaty, signed and ratified by Spain and Luxembourg. Article 10 said, each contracting party should, in accordance with the provisions of this treaty, encourage and create stable, equitable, favorable, and transparent conditions for the investors of the other contracting parties to make investments in its area.
Since Spain has breached its obligations under the Article 10 of the ECT, the claims are entitled to a full reparations in accordance with the principle of customary international law, as is codified in the International Law Commission's articles on the responsibility of the states for international wrongful acts. That's why Spain is obligated to effect restitution by the withdrawing all the harmful and regulation disputes by the claims in the articles that we mentioned before. The tribunal believes that the material restitution is impossible. That's why Spain must pay to the claimants a compensation for any financial damage. The claimants request to the tribunal to award both pre-award and post-award interest on the amounts mentioned before. Spain assumes that the decision of the Spanish Supreme Court will allegedly take issues with the DCF method and is relevant for the arbitration. Spain asserts that the DCF method should be rejected in this case, but however, Spain itself adopted the DCF method in the same context. So that's why from here born another kind of responsibilities for the state. Spain argues that is too much uncertain regarding the future cash flows due the claimants and the DCF method of therefore unreliable. This is also contradictory with their own argument because they works under the new regime's investors are still obligation to return approximately 7.4%.
The ratio decidendi for this case is given by the fact that the decision of the tribunal was to sanction the Kingdom of Spain because they violated Article 10 of the Energy Charter Treaty. meaning that they are obliged to pay all the costs and make the necessary reparations due to the damages caused by Spain to the Luxembourg investments.
As a conclusion, the arbitration tribunal has the jurisdiction over the wage treaty, and as a consequence, Spain had to pay the investors the sum of $124,919,200.